Thank you, counsel. Rebuttal, Ms. Wagner.
Mr. Chief Justice, the United States says that you can refuse to express messages unless those messages are about marriage and unless those views on marriage have to do with believing that marriage is between a man and a woman. That's a significant concession that the government has made. In terms of this issue of categorical denial, the only categorical denial that Ms. Smith seeks, or a categorical request she seeks, is to have message-based protection that the First Amendment already provides. It's based on the message, and in that way, this court decides every speech case based on the message. We can look at FAIR, we can look at Miami Herald, Tornillo, all of the court's cases on speech where compelled speech is applied. You will see the affect or alter the message test, including in Hurley. And in order to rule against Ms. Smith in this particular case, it does seem that the court would essentially have to overrule that Hurley framework. Second, Chief Justice Roberts raised the issue of FAIR and how FAIR applies, and the United States has suggested that somehow this case is closer to that. But in FAIR itself, FAIR was about a duty to give access to empty rooms. The logistical emails that were to send directions to how to go to those rooms was a duty that was required to facilitate legal conduct. This case is speech that's only incidental to speech. When you have a speech creator, you're in a very different space, as the court articulated in FAIR itself, looking at Woolley and Barnett, where you are intruding on the mind and the spirit to force someone to create a message that violates their convictions. FAIR would be a very different case if the law schools were to have advocated for the don't ask, don't tell policy. In terms of whose speech it is, that's come up a few times. At worst, it's both. Third-party perceptions cannot possibly matter to this case, or we wouldn't have any of the other compelled speech doctrine cases. Barnett, Woolley, the newspaper cases, all of those, you wouldn't have any, and the government would have unfettered authority to compel speech because we would all know it was the government that was doing it. In addition to that, the definition of public accommodation. My friends on the other side are playing a little fast and loose with what the statute says and how they've interpreted it in the past. The statute says a place of a public accommodation. On page 41 of Colorado's brief, they say that applies to virtual sales as well, meaning the soccer mom earning some extra income, trying to sell her handmade sign. She's a public accommodation under this law. It is broad, and it would take away First Amendment rights just for opening a business. Certainly, Michelangelo's speech was sold and commissioned, but we would all say it had protection. In addition, the idea that we can't give a bright line. The bright line we give is the line that this court has consistently followed, and I find it ironic in the United States also having to concede they can't give a bright line. For some reason, political speech is protected, but religious speech is not protected under this law. The bright line is the message affected? And as Justice Gorsuch brought up, that line is massive when it comes to the distinction between pre-made speech, plug and play, and speech that you are creating in a custom way. In conclusion, Ms. Smith's speech has been chilled for over 6 years, and the record demonstrates every website she would create a custom message that is celebratory. Colorado asked this court for the power to drive views like Ms. Smith's from the public square. Views about marriage that this court has held are honorable and decent, promises that it has provided that the government would not mandate orthodoxy. Cultural winds may shift, but the compelled speech doctrine should not. Compelled speech crushes the speaker's conscience, and it is the tool of authoritarianism, which is why this court has never allowed it. In the end, it is not Ms. Smith who is asking you to change the law, but Colorado. This court should affirm, again, that public accommodation laws cannot be used to compel speech, and this includes artistic expression, photography, painting, calligraphy, and films, forms of media that the lower courts have shockingly refused to recognize as speech when it comes to marriage. And yes, this court should give guidance to limit the cruelty that has been imposed by endless litigation on artists like Jack Phillips. One need not agree with a particular belief to affirm that law-abiding people have a right to speak their conscience, including on a controversial subject like marriage, and that noble principle is rooted in love of neighbor, extending the same rights to others that we want for ourselves. This right to be free from government coercion of speech is also foundational to our self-government, and to the free and fearless pursuit of truth. Thank you. This court should reverse.
Thank you.